Okay, we're back in Senate Judiciary with Ledge Counsel to go over the new version of SWO.
Good morning. So for the record, Michelle Childs, Office of Legislative Counsel, and everybody should have a copy of draft 1.1 of Senate Judiciary Committee strike all of the S12. I'm going to go through and just go directly to language either that I've changed based on your earlier committee direction to me or comments that I thought you want to change, or also just kind of I did the changes I made in yellow highlighting. Blue, I just indicated areas of the bill that I think are decision points for you that you've been kind of contemplating about whether or not to make changes to those sections. So I'm going to focus on those. So moving to so in section 1, and let's take a look at page 5. And so this is under the very long definition of qualifying crime. And I actually added this language for consideration on lines 12 and 13 as kind of like a catch-all. So there's a provision that I'll show you a little later, the existing law around the expungement of records for 18 to 21-year-olds. After a certain period of time and certain conditions. And that's like one of your decision points is whether or not to leave that as expungement or transition it to sealing. The bill is introduced, moves it to sealing, but I know that y'all were kind of weighing that. But one of the things that's in the existing law has to do with saying that because it's expungement currently, that the court is to keep a special index of records if the expunged record is a registrable sex offense. So I'm thinking if you move to, so it just started me thinking, I was like, well, are there actually any records that would be like sex offenses that would be registrable offenses that might be otherwise sealed in this issue? And I don't know whether or not I wasn't here for the testimony of Jeff Long, so I don't so maybe didn't bring anything up about that, but I just kind of flagged this as an issue to check. And I put this catch-all language in there. And you certainly don't need to, it's just a, placeholder for talking about it, is that, so I think the intention originally was that in the language saying, all misdemeanors except, and we excluded things like misdemeanor offenses under sexual exploitation of a child and things like that. And I think we tried to catch everything in terms of the sex offenses. But I think that there is possible if you look at like what is a registrable offense under certain conditions and things like that, there might be a misdemeanor that is registrable. And I'm wondering if you sealed it, how does that affect that? So I just kind of wanted to bring that up, and I hope I'm not causing more trouble. But I just wanted to bring it up, and I can follow up with ECIC and ask, and the state's attorneys, is anybody and just kind of check with them to see whether or not, and then you can kind of make a decision. Is it appropriate? Do you think it's appropriate from a policy standpoint that under certain circumstances that like a misdemeanor sex offense that's registrable should be able to be sealed? I just kind of put this as catch-all language because I think your original intent was that if it's a registrable offense, it cannot be sealed.
So great. I think it's a great idea.
Because you could also add something, because we're always adding sex offenses and different things, and you could have a misdemeanor and it kind of is there.
Yeah,
so.
This is the catch-all, and I think everybody wants to prevent unintentional change of the law that would allow protection for people who have committed, among other things, sexual offenses. And so I see what you're saying on page 4. We've got sexual exploitation of children covered and stalking, sexual assault, etc. But if there was something, because every time we make a list, it seems like something slips through.
Right.
And so that makes perfect sense to me, just as a way of characterizing a broad set of possibilities somebody would have to register.
Yeah, I think it's a good catch.
Okay, so next changes on page 6 as under, so remember the way that it works is all misdemeanors except for the list, and it's no felonies except the things that are identified. And the court helpfully pointed out that this citation, which again, I think this list originally came from Sentencing Commission, but this is actually not a felony offense. It is a misdemeanor offense that would fall under the eligibility under misdemeanor, so you don't need 5A. So I'd be striking that. So it doesn't change its eligibility under the proposal. I just want to get rid of that language. So the next change is on page 18. And this has to do with the current statute says expungement and sealing for the record. This is, and I think the state's attorneys testified to this a little earlier, saying we hope that you keep it, you know, have it sealing. Right now, there's kind of a bifurcated system of expungement and sealing when there's no conviction or when cases are dismissed, et cetera. Your proposal in the body of the language has not changed, but I think it was just a technical that when I originally drafted it, because you just went to sealing and there was no expungement in 7603, according to the body, I should have struck that language on line 11 because there's no longer any expungement. So it's just something I think I missed as a technical in the title.
So I think this was one of our decision points that we have to figure out, which is if somebody, actually, wait, I might be getting ahead of myself. Please continue. I'll bring it up.
Okay. Next change is on page 20. And this is with regard to when there is a new charge. So current law is that if there is a pending petition for expungement, then the court is not to act on that petition for expungement if there's a pending charge. They wait till the resolution of the pending charge. Because this draft does have some sealing and some expungement, I thought for now you should have both terms. It may be that if you get rid of expungement in the other places, you know,
Then we go back.
then you go back. And or actually you don't go back, it wouldn't be expungement as it is now, it would be sealing, so you'd be replacing it. But right now, even though the circumstances are very limited, you do have the ability to petition for expungement on the 18 to 21 years. So the next change, or it's actually not change, but just the biggie decision point year after year, which is on page 25. And this is on the exceptions for who can see the sealed records and for what purposes. And so you'll just see the language on lines 11 through 14 with regard to access for law enforcement agencies. And did you want me just to walk through everything and then we'll come back to the issues that you want to talk about?
We can back.
So page 25, just law enforcement access, under what the consent says. Page 26 on subdivision 6. And this was just a recommendation from the court, which fine, makes sense to me, is ability to disclose information in a sealed record when required to meet the discovery obligations. It's just a little semantics word thing, but I think it's just changing may to a shall. And that is true. They would be required to do that under Russian rules, and then just striking some superfluous language on line 10. Then on page 27 and continuing on to page 28, subdivisions 10, 11, and 12 with regard to the licensing access that were in the bill as introduced are removed. So that was a decision y'all made some time ago. New language has been added starting on line 13 of page 28. So new subdivisions 10 and 11. And this was what was testified to by DCF and Dale last week. Just a clarification that information materials that are gathered by those departments during a joint investigation with law enforcement, which might include some law enforcement information in their own records, that they're still able to consult those records, those department records, and like taking the responsibility for effectuating the registry obligation. So next is on page 31. And this is just highlighting the whole sections for 7609, starting on line 16, which, as I mentioned, so this is, existing law around expungement of records of someone who was 18 to 21 years of age if they committed a qualifying crime. And then again, the issue on page 32 around, that's the special index language. So I think if you have the catch-all language up above in qualifying crime, you don't need a special index because there's not going to be any sex offenses that are going to be going away. So I think it's just a kind of a cleaner way, because this, when I first read this, I was like, wait, what sex offenders? And it really took me some time to try to look at all the different, like you said, we have so many lists, and like to compare the list of registrable offenses and is it offense if the person's under 8 only because the person's under 18, all that kind of stuff. I think it's a cleaner way, as long as it fits with your policy goals, to just have the catch-all that when you're talking about qualifying crimes, you're not looking to seal or in this case expunge sex offenses. But like I said, I will put this out to maybe state's attorneys, UCIC, Defender General's office, just to double check, make sure I'm not missing anything. Next decision point is on page 34. And this is on deferred sentences. So, so the proposal that you have in the bill is introduced changes what happens if you successfully complete your deferred. Right now, under current law, and it's always been that way, if you successfully complete your deferred sentence, your record is expunged. So that's just a policy decision for you, whether or not it would be continued to be expunged, or whether or not you would want to change that to sealing. If you are going to change it to sealing, I would just wind up adding some language here to clarify that we're talking about people who are sentenced after the act. So it's not, you don't want to get into tinkering at all with, sentence that somebody has already pled to, and they are under the impression that once I successfully complete this, my record's going to be expunged. You don't want to change that.
Sure. So in this particular case, are we just looking at like putting a start date or something in here? Or?
Well, it was my understanding that there were some members who were like, you weren't entirely sure whether or not you wanted to change from expungement to sealing. So the bill is introduced, does change it to sealing, but I thought I heard some hesitancy.
Yeah, I think there was
from the committee.
That is a decision point in which we have to decide if we want to tinker with what we do with deferred sentences, whether or not we want to leave it or allow them to be sealed or expunged. So yeah,
Is that, I'm remembering now, Valerio, that was his number one problem with the bill, and returned to it again and again. And it made me rethink why are we changing it to sealing? I mean, I know we're trying to move to a single track, and ideally everything would be on that one track, but what we would be doing in effect is getting rid of most expungement, but we would still have a couple of the pre-existing areas. And so sealing, it seems, or expungement could remain for deferreds, and it would be the practice that we've always had, or I think he said 50 years.
It's that's probably true. He would know better than I would. It's been there long before I started in the 90s. So
yeah. So I agree with Senator Hashim that the person for whom the record pertains should always have access to that record, which I guess in some sense moves us slightly away from what we do now, which is completely delete it. But I think, when we're talking about a single track, it's assuming that everything is treated exactly the same, which I don't think we're actually discussing here. We're talking about not just deleting stuff. But I actually think we are talking about sort of different levels of access potentially. And so I guess on the one hand, if we're sort of saying, no, we're not gonna delete it, we are getting rid of what we do now, but if we're saying for this group of people, and I would just believe this group of people would be one of them, as well as people who have something on the record that's no longer a crime, nobody has access to it, except the person it pertains to. So I think that it's sort of this middle space of like, I can come to a space where I support not just deleting. Given some of the things that Senator Hashim has brought up, just in terms of like, if I'm 20 years from now, I'm like, hey, was there prosecutorial misconduct? I should be able to go back and get the record that pertains to me. But in those instances now that are expungement, and I think you and I both support remaining quote unquote expungement, I don't think anyone but the person it pertains to should get access to it.
And I can agree with that. Do we have language in the bill that does that creates, what do you call it, subject only access?
I don't think we have language for that. I think that could be a place that we go of just ensuring that on completion of a deferred sentence, the defendant shall receive their full case file and all discovery related to it. I think that's something that should be done, but I don't think that language currently exists.
Because I'm wondering, and now I'm remembering when we had the original discussion of it. I agree conceptually, but it seems like if there is a record, a judge is always going to be able to get access to the record. I mean,
if it's expunged, I don't think so.
well, I mean, not expunged in the sense of destroyed, but if we created, so let's say that we said deferreds could only be accessed by the person who had the deferred sentence, the subject of the sentence. It seems to me that we're always really saying a judge could look at that record, right?
I don't think so, because if you're taking every document, what I'm envisioning in my mind is literally the hard copies. Here's the video footage on a thumb drive. Here's charging information and affidavit. On a piece of paper, here you go. And now we're destroying everything that's in the courthouse.
Okay, I had been thinking that it would remain in the system, but only the subject could see it.
Yeah.
But you're talking about, what if there are electronic records, those would get destroyed? Or said you put them on a thumb drive?
Yeah, that's
And hope it doesn't get ruined in a flood.
right. So it's a little strange, but I think that if there's, I just don't think it should be completely destroyed, and providing it to the defendant, I think makes sense. I'm also hesitant about completely changing this thing that we've had for 50 years. That the Defender General seemed to be one of his top priorities for this.
Yeah, I'm just wondering how the people, because it would devolve onto a clerk of the court, right? To get the materials to somebody physically.
Yeah.
Because they don't do that now.
Right.
So I'm wondering what that would involve in terms of extra work and trying to, what if they can't find the person? Do they have to make a good faith effort and they can destroy it?
Oh, technically they're supposed to update the court with their new address. Independently, but I'm not sure. I'm just it's just an idea.
If I could, I remember, so I was listening to when Matt Valerio testified, and I think he was reminding everybody that in terms of the defendant having access to their own information, right? So like they have the attorney, that person's attorney has all of, or should have all of that information in their case file, and that attorney is required to retain that information. And so they still have that. They still have that. So it's not like it doesn't, like every single, shred of paper that indicates that it's gone.
Right.
So that should be available, and that is regardless, they're always going to have access to that. And then I also just did want to note that under the current deferred statute, VCIC has to have a special index of deferred sentences for sex offenses that require registration. The index has just lists the name, date of birth, of the subject of the record, the offense that they were convicted of, the docket number of the proceeding. The index is confidential and can only be accessed by VCIC and a designated clerical person for the purpose of providing information to DOC in preparation for a pre-sentence investigation. So there are different points and, you know, and people may, you know, probably the people who have to carry this out probably hate the special indexes, but there are different places in law, like what you're talking about in terms of if you feel as though there needs to be some type of index that contains something where the record exists, but you don't, but you are either, you know, denying vast majority of access to it or
So those already exist.
currently. Yes.
Okay.
Yeah, but it has a very, very limited purpose there for, you know, so I'm done with my walkthrough. So now y'all just have to get to the hard stuff. The hard questions.
Where to start? Initial thoughts from the committee regarding some of our decision points, so we have to make.
The biggest thing is, my mind is we've got the 18 to 21-year-old deferred sentence that is, and then we have the other section. And I think we needed to ascertain if we're going to a single system or making carve outs for the 18 to 21-year-olds as long as, and the also the deferred sentences here, what works in the best interest of justice and the individuals charged as a whole here. You know, we're going to come back another year from now saying, okay, let's go back and look at the 18 and 21-year-olds. I don't want to keep revisiting this thing, which seems like forever now.
Yeah.
So hard decisions to be made right there in that solution process. We want to.
Yeah, and I would add to that regarding the timelines, in which somebody has to wait until getting until they're eligible for expungement. I'm not a fan of removing offenses that could be eligible for expungement, some of it's nonviolent property crimes. You know, I think that if somebody is, you know, on the right track for a decade, or, you know, somewhere between 7 years and 10 years, with no new charges or convictions, their former charge was a nonviolent property crime. I think that removing that kind of defeats the purpose of what the underlying spirit of expungement / sealing is. So
So
That's-
you're referring to 7609, what you're talking about, or?
7609, I think it's.
Page 30.
Uh, 7609 is 18 to 21 years of age.
So page 34 then, and for 7041.
The 7609 is the 18 to 21 years old, so that's on page 31. Yeah. And also, I would just note there, I found this a little confusing in the sense of like it starts out, this section starts out saying that the record of the criminal proceedings shall be expunged within 30 days after the date of completion. But then if you have in subsection C saying that they can petition at that, I would just like to kind of rearrange that section if it's okay with you guys and just put that out there and people can, you know, stakeholders can comment, whatever. I think it's a little disjointed in that it makes it sound like it's something that's automatic in subsection A, but subsection C says that they can petition within 30 days of completion. I think it could be clearer if I just rearrange that a little bit. if that's all right with
That's fine.
everybody.
Well, while we're on the topic, let's just talk about the 18 to 21 years old folks and whether or not we can stick with expungement or move sealing. I mean, my concerns about expungement in general apply to everybody, regardless of their age. I do want to keep it at 30 days so that they can much more quickly access the benefits of sealing. But I think it, again, destroying the records just for that age group, I'm not sure that it necessarily makes sense. So that's my initial thought on that. I'm open to being persuaded or hearing other thoughts.
I could agree with the 30-day petition on assuming the records on 18/20. It's the same purpose.
I mean, a lot of whether or not I can agree to that depends on who has access to the sealed records.
Yeah, I was so what we talked about earlier, what we got testimony on, was the idea of creating a statewide policy so that there is some consistency in terms of how a police officer can access sealed records. We got good testimony from Sheriff Anderson, who's still here, about that process, but I do see the concern of that there potentially not being consistency between one police department and the other. And I mean, we would also want to hear from the Criminal Justice Council about this, but if there's improper use or improper access to a sealed record, there could be the risk of decertification. I was hoping for us to get a proposal from the state's attorneys. I may have misunderstood, so we don't have that language quite yet. But I do think a statewide policy that at least has some teeth to it would make sense. And if not a after hours process in which a motion can be made, sent to the judge and reviewed to access those records. But then we're butting up the exigent circumstances. But I still think that,
It's hard to believe. Oh, I'm sorry. Go
yeah,
ahead.
no, after hours phone calls are made to judges to get, warrants approved. And, if we're talking about a BCI investigation, I feel like a motion to access sealed records is going to be relatively easy to do, but, that's something that we want to hear from Senator.
And I just chime in on that last point. I think that's really important because you talked about cold cases, and we've talked about these very rare opportunities where you might need to bring up somebody's sealed record. The fact that it's very rare says to me that there would be almost no use of the ex parte piece anyway, so it wouldn't be burdensome, I wouldn't think, for the judge or for law enforcement, but it allows us to square that circle where there's just, somebody who using judicial discretion to determine whether that sealed record needs to be activated.
Yeah.
And that would give me a lot of confidence in, these other decisions and not the 18 to 21-year-olds that influence, et cetera.
So what the sense that I'm getting is there would, correct me if I'm wrong, but there would be a general consensus of having the 18 to 21-year-olds go to sealing so long as there is a judicial review process to access those sealed records. In the event that they're many years later trying to solve a cold case, or there's some breadcrumb of clues that have led to needing to get access to those records to resolve a very complex, serious offense. Is that what I'm getting at?
That's my belief at this point.
Senator Mikulski?
I think so, but I did want to hear from Marshal Paul about, because, the Defender General, and as you know, he's the juvenile
Yeah.
person at the Defender General's office and they testified as to what is in the bill. And so I would want to hear what their thoughts are on that shift before I would feel.
Yeah, reach out to Marshall. please.
I think if I just made, so I think I'm gonna be doing a lot of redrafting of this section for the next one. So I will just say is, I will work on this section. I've heard kind of what you've said here and want to rejigger a few things, to make it more consistent with what you've done elsewhere in the bill. And then, I can send, just this one section, you know, to Marshall or, you know, to Kayla to whatever, just as an aside. Does that make sense? That way, I'm just trying to think about rather than we just think it's along on this one point. I'll share that and then, you know, we can figure out what you want to do with the rest of the bill.
Yeah.
That'll keep moving at the same time.
Great. So,
So that we don't have to redraft this 100 times here. Is it my understanding that the 18 and 21-year-olds, and I agree with what was said, will go to a ceiling versus an expansion process. However, roadside stops, in essence, 99% of the time, just won't happen. So we always have to keep in mind the exigent circumstances surrounding it. We just can't put a wall up that says no. Okay, they're gonna have to justify as to why, but I still say that 0.1% of the time, as long as it has judicial review, they should have access, at least apply for access to the record. I just want to make sure we're straight up instead of agrees on this before we. Is that my understanding?
that they can access the record, the sealed record, so long as they go through a judicial review process.
Yes.
Yeah.
And I would assume that, you know, depending on the reason whether else we can detain roadside anyways. Briefly, but it's work on application for a warrant, because I'm not going to get a warrant, I'm going to apply for a warrant versus the old adage. I don't have a problem with that.
I feel like I cannot envision any scenario where, you know, you're,
Yeah.
I mean, you know, on the roadside applying, I mean, it's applying for writing up a motion to access a sealed record from 15 years ago on the roadside. I just feel like it's not going to happen, but I think there are other circumstances though, where, you know, if you're, again, doing some in-depth investigation with multiple detectives, you find something and you're like, oh, that there's a motion that we have to file to, you know, get that record.
I can go along with that, as long as you don't simply cut all the arms off here and say, no, you can't do this stuff.
Yeah.
There may be that reason to which we can't ascertain what it is presently, but we don't want to say that you can't ever do this.
So I just want to clarify and just remind people that we're only talking in the universe of qualifying crimes here that would be potentially sealed under this section. And so it's just going to be minor nonviolent misdemeanors, a handful of felonies and stuff. So I guess I'm thinking about in terms of what value they serve in terms of a roadside stop, right? There's nothing around, you know, firearms or violence or those, you know, fleeing jurisdiction or anything like that, that would be considered a qualifying offense. And then also is the end purpose of what this would mean is that instead of the 18 to 21-year-olds for a qualifying offense having to follow your schedule of you wait a certain number of years, things like that, that they could petition for their sealing 30 days from the time of completion. So it's just as fast tracking those. And then the other difference would be that you wouldn't allow the exceptions that you have currently in there for everybody who can peek at the sealed records for the various reasons. You would only allow anyone to view the sealed record upon judicial review, but you haven't determined what would be the court standard for granting, right? I mean, I can just kind of put a placeholder as like in the interest of justice, but that's a big policy choice for you that, you know, you'll probably want to hear from witnesses on. And Tanya already mentioned, you know, hearing from Marshall about that. It's like, what would be the appropriate standard for the court to make a decision that in a particular case, it warrants releasing the sealed or granting the access to the sealed record.
So it's sort of judges on that,
So you're going to ask Chris Merkel, the director of the Office Academy, or? in reference to the policy that we may or may not be.
Well, I don't know if we're going to be going the direction of a statewide policy versus the direction of the motion. The state's attorneys seem to propose two ideas. To have a statewide policy that has some teeth to it, saying that, you have to follow this policy. If you misuse sealed records, you're not a cop anymore. Or rather, you're at risk of losing your license. And then the second, which is, I guess you could describe it as the stronger step, is to go through the judicial review process, filing a motion, have a judge, next part they motion, have a judge review why you need to access sealed records. Same those.
I sort of still have the question that I've raised again and again and again. If this moving towards a sealed record versus an expunged record means that someone, a member of the public, has to know what circumstances they can say, no, I don't want a purple record. Because, so I'm pulled over, police officer says, do you have a criminal record? I say no. They see that I have a sealed record. Does that mean that I just lied to a police officer?
I don't think they can see that you have a sealed record. If they have to go through that process, getting access.
So how would they know? If they can't see I have a sealed record, how
Oh,
would
well,
they
if
know
you're
to go
running
through the process
running-
to open the sealed record?
Right, if you're running the see for Florida.
I would just mention, and I realize it doesn't necessarily mean that it translates out, in the public to what people don't know, is that under current law, and that's continued in your legislation, it says that for sealed records, anyone can answer to a request about, do you have a record, can say no.
Mhm.
And so I think that extends to if a law enforcement, like your official line is, no, I do not have a record. Whether or not, that's kind of hard for folks to understand if they have a sealed record, But hopefully through the petitioning process, they would be provided with information, and that would include it on there and with the order that says that.
So of course.
And I think, in response to Senator Oski's concerns are, even if the officer has personal knowledge or whatever else, that still can't be used against them because the record is sealed. The personal knowledge or for social media, where it's not the cause or charging for, well, I happen to know what you have. Okay, so the individual who says, no, I don't have it, because the record's been sealed, I don't think they have the right to say that. Right. Looking at in their best interest.
So I think that covers the 18 to 21-year-old section. Unless there's additional thoughts. No, okay. The section on deferred sentences. So, and part of me, I'm gonna say there's a part of me that, I mean, to your point, Senator Norris, yeah, it probably will be revisited, but it's, I also don't want perfect to be the enemy of good. And I think that I'm of the mindset to just leave deferred sentences as they are for now. Yeah, they'll likely be revisited, and yeah, the House actually may do something on its own. So, but considering time constraints, it's one thing to consider regarding deferred sentences. But if there is a proposal as to whether or how we change deferred sentences and whether or not we should get rid of expungement for that, open to hearing that conversation. Senator.
Question for Michelle. Am I understanding what you said earlier? So that the chair and Senator Oski have both been talking about wanting to the defendant to still have access to the record, but under the current expungement system, they do have access in the way that you were talking about, that their attorney.
Yeah, they're always, no matter what you do here, their
Yeah.
attorney's always gonna have their records, right? And they have access to that. The question is, could they go and access them through the court, the court or some, something
So
like
if
that?
that's the case, then I don't understand why we would change from the current
Mhm,
system.
I agree.
If we take the Matt Valerio route and just leave deferred sentences alone, the defendant does have access, but nobody else does. And we're not monkeying with something that's not broken. I haven't heard that it's the deferred sentences that are driving the, what now seems like overuse of the system or a backlog of people trying to get expungement. It was the, offering the broad-based expungement that produced that.
Senator Reynolds?
Agreed. If the attorney, the defendant's attorney, provided they have an attorney, always has access to the
Well,
records.
they're gonna have an attorney in a criminal case that was resulted in a deferred, so they're not gonna be unrepresented. I would say one thing that I would just say that I don't know, because I haven't been in private practice, is that, management, and I assume there are procedures for all of this in place, but let's say, you've got an attorney, who is retiring, how are they dealing with all their records? And you might want to hear from someone on that kind of issue, with just about continuity and making sure that records are returned to the client or whatever is there, so that if you do have a retiring attorney.
You read my mind. That was actually gonna be my question, was about retiring or the death of an attorney. Like, I know as a social worker, I have to have a quote unquote professional will for where my records go if I.
Right, and I'm sure that there's a whole process for that, but because I'm
There are
not a private
professional conduct
practice,
rules.
I'm not familiar with the professional conduct
Yeah.
rules around that procedure.
There are rules, I just don't remember what they are.
Should be helpful to
Yeah.
hear from a defense attorney what those rules, or someone who knows those.
Right, when the Defender General's office talks to you about these other things, they can
Mhm.
probably address that.
Mhm.
Uh,
I had another question, but now it has fallen from my brain. So maybe it'll come back.
So I think, actually, committee, any further discussion on the deferred part? I think the next decision point might be how much time we want to require for an individual. You raising your hand?
I'm wondering if there are national experts on desistance and recidivism that could give us the sort of like brain science lay of the land to help us make that decision.
I think the crime research group is the one that came in last time around to talk about the amount of time necessary, from somebody first being arrested for an offense, the length of time which they get to the same place, of the likelihood of recidivism being the same as somebody who has never offended in the first place. So could we please add the crime research group? Thank you.
We're talking about 3 years, 7 years, 10 years, right?
Yes, and that actually just reminds me, I think there was an email from the crime research group that I forgot to respond to, in which I reached out to them actually for like, so glad we brought that up. Anyways, yeah, any thoughts on the timelines?
I don't feel like I can have a thought until my brain's been refreshed around the science. Like, I don't want to just throw darts at a random person.
So I only picked this issue a few years ago, and Brenda was doing it before, and I can check with her, but, those numbers came from somewhere.
Yeah, I just want to know where they came from.
And I'm trying to remember, and for some reason, I feel like maybe CSG had worked with the committees. Does that ring a bell for you around? I'll see if Bryn remembers. I mean, I could just trace back to some of the stuff, but I feel like perhaps it might have been, CSG that was working with the different committees on the recidivism and how to kind of pinpoint those numbers for misdemeanors and felonies and stuff. So I'll just circle back to you and to Kayla if I have any better information.
Thank you. That would just be really helpful because I think we have peppered all throughout law places where people picked a random number and the science has showed that that's not the number that makes the most sense. So I don't feel comfortable even really having the discussion until we have the.
Right,
The
I think it
research.
was the Justice Center, which would probably make sense because Senator Sears was so involved in working with CSG's Justice Center over the years, especially on the juvenile issues. So I'll double check.
But I think it's also possible that CSG or whoever does the research picks a random number. And like, let's say they pick 10 years and they show the difference between 10 years and 1 year. They could have picked 13 or 14. So at some level, I guess it is a matter of selecting a likely possibility. Unless, who knows, maybe they really do show a market drop on it, which is like year 14 for the rents.
Maybe they got it right. Understand?
That's what I'm saying. What's stranger things about.
Any additional thoughts on this? Sounds like you need to hear from some people before making any big changes.
Yeah, because I personally wouldn't want to open it up. Floodgates like you were talking about before, is make one exception for this industry. You're gonna have every other industry come in.
Yeah.
We don't have that same thing.
Yeah.
And I'd love to know more about, these 3, 7, 10 and hear more about, if it actually does, you were alluding to, it might take a year or two to even get to ceilings. So then that adds another year or two onto the 7 years after they do their sentence. So it might even be 10, 12, 13 years
Yeah.
after it happens. So yeah.
So
So you still have, I'm just checking to make sure I didn't miss it, on the issue of general law enforcement access. You guys are still, you still have.
yeah, I think on that topic, the sense seems to be that we want to get that language regarding the motion for an ex parte review as to whether.
So this is something that's coming from the state's attorney's office or?
Yes.
Okay.
Yeah.
So it's not something, I just want to be clear on what I.
Oh, okay, yeah.
I just want to make sure I didn't miss anything that you wanted me to do on that one particular provision.
Not at the moment.
Okay.
I asked today for them to do that, and so hopefully we'll get that soon. Send them out.
Yeah, the other piece I don't see a change on, and it has been a sticking point for me, is stuff that is no longer a crime. I still feel like that should be expungement and it should be conditionless.
I don't see why not. Because I mean, in that case, the only possible objection I can see is your blanket
Yes.
objection about any state action.
Yes. And I agree with that. It just doesn't seem like we've landed in a space where that can disappear for everyone but the defendant. And when I weigh those two things, I suspect the majority of people are going to be more comfortable with the record not existing than the number of people that are going to come forward and be really mad that that record doesn't exist anymore.
Yeah.
And if we found the space where they're the only one that have access to it, I would be really, really very much more supportive of that than expungement. Some of the found it.
Well, I think they would still, Michelle brought it up earlier, that they would still have access to their own records. The attorney had to retain records for a while.
If they had an attorney.
Well, if you're pro se, you're gonna get your own records.
Okay.
If you're-
So we're good with just expungement.
Personally, I'm not, but that doesn't mean that's how we have to go with it. I mean, I think that I see your point, but I also see the fact of, somebody many years later saying, look at what the state used to prosecute people for, and, now it's no longer a crime, and I want to seek justice in some way, for this thing that's no longer a crime. That's my issue on it.
I'm confused because I just said that I agree if there was a way for someone to be able to access that record on the same grounds. And you said they can through their defense attorney. Like, I'm confused because I feel like we're saying the same thing, but coming down on different sides of it.
Right, so if I understand what the chair was saying would be if we completely expunged people who are the victims of the state action, determined later to be victims of the state action. Like, for instance, disproportionate prosecution of marijuana offenses.
Yeah.
We legalize marijuana now, but what I hear you saying is that somebody might later on want to show that there were disproportionate prosecutions, but if they're all expunged, the state action is expunged, they are without evidence that happened.
Yeah, and I mean, it would be an extremely
Rare.
narrow and unlikely situation in which perhaps prosecutor wants to say, I want to go after, this former police officer who was, mishandling all these cases. And all of these cases, all these charges are no longer a crime. And I want the information about what that cop did. I mean, I feel like the chance of that happening, honestly, is extremely slim, but it's again, it just goes back to my root belief that we shouldn't be destroying records, but it's not gonna, I'm not gonna die on the hill for it.
Yeah, no, I'm actually still confused because I was saying, I agree with you wholeheartedly, but short a path forward for the super sealing where the only person who can see it is the defendant. I think it is such a rare instance that the mechanism of sealing we're moving towards for things that are no longer a crime would do more harm than having the records gone.
Yeah, I mean, so the defendant would have a prosecutor who wants to go after the prosecutor, law enforcement who wants to go after some other bad government actor wouldn't have access to it. Again, 1% chance, if not less, of this happening. So I'm not, again, it's not something I'm gonna die on the hill if I would keep it expunged, more or less.
So are we simply just talking about cannabis, or is there a whole tablet full of things that are
I
no
think
longer?
this is something I just wanted to raise the issue, and I talked to you a little bit last time you brought this issue up, is is one area where I think could be difficult in terms of doing a petitionless sealing, so doing it something automatic as opposed to somebody filing a petition, is we don't know all the offenses through the decades that have been decriminalized. So cannabis is is clearly in our mind. It was not that long ago. You went from illegal, you went from criminal to civil to legal. You also did something that was pretty unprecedented, which is that you directed the court to do automatic petitionless sealing of all those very specific offenses. But I don't, there's many things that, before you had Judicial Bureau, right? That all just were district court and they were crimes. And then there's been a shift, right? And through the years to move minor misdemeanors into Judicial Bureau civil offenses, to decriminalize things entirely or whatever. And there may be such a list out there, I don't know. But it seems as though, you could do expungement, but you could do, if you did petition, and somebody could say, here's my record, here's my charge. They could look up, they could see, oh, right now this is like a civil ticket for $100, or this isn't even an offense anymore. Boom, there's no other conditions. Your only condition, you don't have to prove that you completed your sentence. You don't have to prove that you have restitution, whatever. You just be like, this is no longer an offense. And that's the basis. But I think doing it automatic creates problems for the courts, but I'm sure Judge Zone can address that for himself. But I just wanted to raise that as a logistical issue.
I appreciate that. And I have a problem with it being on John lay public to be following every little thing that's happening. And we don't know, how do we expect the public to know? But I'm also thinking more forward thinking. This is going to apply forevermore. So I'm also thinking about, say down the road, we, I don't know, decriminalize sex work. I would want part of that process to be anyone who's previously had been charged with that to have their record expunged. So I'm not just thinking retroactively, I'm thinking forward as well.
And you would want it to be automatic.
Yeah.
Petitions. Well, and definitely the petitionless sealing in terms of workload is maximum for the court. Not that should be our one way of thinking about it, but it is true that we would set them up like, it was something like 90,000. What was the amount of, we had a number at one point about the number of offenses they had expunged under the cannabis
Oh, yeah, I have it in my notes.
It was a
Look
lot.
at it. It was a lot. And did you guys ever hear, you guys, when the ceiling bill kind of crashed and burned last year, there was one little piece that survived, which is you directed the court to come back to you with a report on petitioner's ceiling. Did you guys ever hear from them on the petitioner's ceiling
I don't think.
report?
Might have the report.
It might be.
You definitely have the report. I mean, so reports when they come in, you know, if they're directed to certain committees, they'll go to the chairs of the committees. And you know, sometimes whoever's sending them will know to send to like me or Eric, you know, or Ben. But they're always on our website. So on your legislative, you know, reports tab there, you can find it there. I know I have it. I have it actually in my file right here.
Oh,
Frankly.
I was
I mean, it's on the website.
If you have keywords for me to, I can find it.
Yeah.
Thank you.
So you can just look it up by date or that it's from the chief superior judge.
Do you want hard copies of it? Or do you want-
I think if you could send us an email with it in a PDF, we need hard copies, right? But reference it. Any other decision points that we haven't discussed yet?
So should I do anything different on the next draft on the issue of offenses that are no longer a crime? Or just leave it as it is and people can comment on
So
it?
as it is that offenses that are no longer a crime are eligible to be petitioned to be expunged, right? That's the.
No, see, it shouldn't to be sealed. And I think that's what Tanya was saying, it should be petitionless and expunged, not sealed.
Yeah, but if they're sealed, they can still be accessed, and that's the current line. Just thinking out loud. For the rest of the committee thing.
What's the question again?
The question is offenses, so our current language provides that something that is not a crime anymore can be sealed. If the defendant petitions the court for it. The proposal is to make it so that something that is no longer a crime can be expunged. And there's the lingering question of whether or not petitionless expungement is feasible, which I think is in that report. So that's, the main question is switching from sealing to expungement for things that are no longer a crime. Yes or no?
I'm not in favor of expunging records, government records. If it's sealed, it's sealed. The individual still has access to it. I'm certainly not in favor of stealing or expunging potential, as let's just say the sex worker bill, prostitution, of something that hasn't even passed yet. Okay, so when that happens, then we'll address that. But until it does, I'm not in favor of looking down the road at other.
Senator Maddox?
Yeah, I kind of feel the same way. I wouldn't want to just destroy those records, but I am in favor of sealing those records. And I really worry about the petitionless part of it, where the administrative workload of the courts to be able to go through all those.
Yeah.
Those cases. So, and I don't know from a like attorney perspective how those laws, you know, say it's a misdemeanor marijuana charge that you're convicted for, and how that actually plays into something that you do tomorrow because it's no longer.
The attorney answer is that that's okay. Yeah. Well, I think perhaps we can put a pin in that section. So I don't think at the moment there's anything that we need to change for that, but I think we'll revisit the discussion. in the near future.
So I'll work on a new draft. I think it's not scheduled again until Friday. And so I will send that new draft out to Kayla at least, you know, right by tomorrow morning, and she can send it to y'all and I guess any stakeholders who you might want to have commenting or working with you on Friday on the draft.
Current law is that if something's no longer a crime, it can be expunged.
I believe so. Okay.
So I just want to be clear that current law, that this bill would be taking that away from someone who currently has it.
I thought it was, maybe I misheard. I thought stated that it was, they would be sealed under current law.
Under this proposal, I'll have to double check if it's an expungement under the. But under what you have in your language in S12 as introduced as not changed in this is,
Sorry, I'm kind of confused. So
sorry.
let's say this S12 doesn't exist.
Mhm.
If something is no longer a crime, somebody petitions, are they petitioning for sealing or expungement right now?
I have to look. It's expungement.
So if this passes, they no longer have access to that. We are taking that away from them for things that are no longer crimes. I don't think I can support that. Unless we have a mechanism to do the super sealing, which it seems is even more work or possibly impossible.
Committee, any further thoughts?
We're reading the email here. Forward.
Send that out, something?
Nope.
All right, I think, or Michelle, anything?
No, just that I'm gonna reserve, you know, let me hold off on the, if it's a no longer a crime, the
Yeah.
expungement of the
Okay.
ceiling, because I'm proving the point that you have to go through a little analysis.
Yeah. I think, yeah, this is one of the most confusing things, actually, to try to explain.
Which
to
is part of
clients.
why I don't think we should put it on the general public to figure it out. And in some of these instances, it should just be on the state to fix it.
We can, take a break until 11:30.